This program intended for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts. Different jurisdictions have different laws and regulations. So because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Well, there's one of those right across the microphone from me. Marshall Chriswell, good morning.
Good morning.
Hey, I wanted to, because the last time you were here, the last couple of times we were talking about estate law. And you came in today and you said, we've been talking about estate law, and I got a couple of really good examples recently of reasons why you should make sure that your estate is properly being handled. So what are those examples?
Well, what I always recommend, so if you have estate planning documents, if you've got wills or a trust or powers of attorney, things like that, you've got to take a look at those periodically and make sure that they're updated. Have an attorney take a look at them, whether it's the attorney that drafted them or get a consultation with another attorney you're comfortable with, and sit down, just take a look at them, make sure that they still meet your needs, and make sure that changes in the law in the meantime haven't made them outdated or caused some sort of a problem with them. And that's exactly what I've been seeing lately. I had a couple of examples, like you said. Number one was a client, an elderly client, and his daughter got in touch with me and said, "Hey, we've got this power of attorney for Dad, financial power of attorney, which would allow the daughter to do things like write checks from Dad's bank account, or manage his investments, or sign things on his behalf. That if he became incapacitated and was unable to do that, and this client happened to be the father was in his 90s, so that it's foreseeable that something like that could happen in the relatively near future." So what occurred was they took this power of attorney document, and then the daughter had the foresight to take it over to Dad's bank and say, "Hey, sometime I may need to use this document. Can you put it on file for me here? Can we get this set up?" And the branch manager looked at it, ran it by the legal department, and said, "No, sorry, we can't accept this. It doesn't comply with current Pennsylvania law with respect to power of attorney documents." And that law has changed a couple times over the years, but most recently, there was a few years ago, there was a big change in some of the language that is required to be in those documents, and she would have never known, and it would have been a huge problem, if Dad would have become incapacitated. But luckily, despite the fact he's in his 90s, he still is in good shape to sit down with me and sign a new document, and we were able to avoid that problem. Wow. But it could have been a really big problem.
And see people getting into a real difficult situation because they haven't kept it up to date.
Right, and you would have no way of knowing as a non-lawyer lay person. You're not following these changes in the laws.
I think I've taken care of that. It's all settled, and I don't have to worry about it anymore.
Right. And this was something that was done back in the early 90s. So
okay.
Yeah.
Right.
So I recommend at least once every 3 years to take a look at those things.
Okay.
Yeah.
Was there another example?
There was actually, and this one is a client, another elderly client that had estate planning documents done back in the early 2000s, late 90s actually. And this woman she's a widow, lost her husband a few years ago. And her husband, like I said, back in the late 90s, had prepared a trust. And that trust was for the benefit of their two children. But the trust itself, it's what we technically call it an A-B trust. And the purpose of it was whenever the first spouse passes away, it created a portion of their estate, a portion of all their investments and everything that they'd accumulated during their life was to be placed into an irrevocable trust. Irrevocable meaning you can't change it, you can't touch it. Even the wife, the surviving wife, she can't touch it at all. And the reason for that was to avoid federal estate tax. Okay. So they had this, and it was a good plan at the time. But over the years, the laws have changed significantly with regard to federal estate tax. Back when this trust was signed, your estate would be taxed on anything over $1 million. Okay, so that includes your retirement accounts and everything. So there are a significant amount of folks that have over $1 million in retirement savings and things like that. But in the intervening years, come up to present time right now, that threshold for estate taxability is $11 million for a married couple. There are very, very few people that need to have planning, specific planning for avoidance of estate tax anymore.
So that trust is, while it's still valid, it's no longer necessary.
It's no longer necessary, and now it's actually causing a problem for her because she needs some of those assets, or would like to have some of those assets to live on. And she maybe would like to sell her home and things like that, but they're locked into this irrevocable trust. And there are ways that we can go back in and fix that. If we have the children on board, all the beneficiaries of the trust and they're on board, we can get a court order. There are ways that we can fix it, but you've got to fix it. And so that's another one. Things that you thought it would seem like a great idea at the time, but in those intervening years, the law has changed, and it's no longer necessary, and it's actually more of a hindrance.
So when we say in the disclaimer at the beginning of the segment each time, the law is constantly changing, the information may not be complete or correct depending on the date and your particular legal problem, that's exactly what we're talking about.
Yeah, exactly. And again, you'd have no way of knowing that. Most people aren't researching tax laws and estate law. So you've got to talk to an attorney. Like I said, at least once every 2 or 3 years to know those things.
All right. So if you haven't done that in the last 3 years, it's time to get up to date on that.
That's right.
All right. We have a few minutes left. I wanted to talk, if we could, a little bit about landlord and renters. Issues, because with the start of the new semester, some folks are moving into rental income or rental houses along and around the IUP campus. There are specific laws that are in place, and I would guess the landlords are pretty up to date on it, even though there may be some fuzzy points. But certainly students renting an apartment for the first time in their lives, they need to be up to date as well, don't they?
They do, and I do have a landlord-tenant practice. I represent both landlords and tenants, and on a regular basis. And you're right, students. I'll tell you one big thing that students need to understand, and it's something that I get called on usually at the end of the fall semester, towards the beginning of the spring semester. I'll get phone calls from students and from parents saying, "Hey, my son or daughter attended IUP in the fall. A lot of times they were freshmen, maybe sophomore, and they went and they signed a lease, and they're in this apartment with three other people or four other students, and something happened. They had a medical issue. They had they had issues with their grades. Whatever it is, they're not coming back for the spring semester.
Yeah. Okay.
So we've got this lease, and now we're obligated to pay. And some of these rents, I mean, I can't believe it. We're obligated to pay $6,000 for our student for rent for the spring semester, but he's not going to be there. What can we do? Oh. And the sad news for them is,
the answer is
that you've signed a lease, and unless your son or daughter can find a suitable replacement that's acceptable to the landlord, it's very likely that they're going to be on the hook for the entire year because they've signed a lease for a year. And people say, well, that's hugely unfair, and maybe it seems that way, but that's the contract that you signed.
That goes back to that contract that you signed in the very first place.
That's right. That's right. Yeah.
Okay. So that is a big issue, and I would guess that that's more common than we might think.
Very common. I get many calls in that regard every year, and sometimes we can work things out. Sometimes we can negotiate with the landlords, and sometimes maybe there are reasons that the student might be due a partial refund. But by and large, what that lease says is it goes.
Understand what you're getting into at the very beginning, which probably means get in touch with an attorney to help you review that document before you sign it.
Yeah, and it's something nobody does. People, you're going to sign the lease, and you think, okay, this is the form the landlord has, and it's non-negotiable, and I'm going to sign it. And well, you do have a choice. You have a choice. You can present things to the landlord that you might want to be changed, and we know that here in Indiana, we have more rental units on the market than we do students to fill them right now.
Yeah.
So sometimes you have a little bit of negotiating leverage, and also you can find another place to live.
Yeah, it's a tenant market right now.
It kind of is, yeah.
Yeah. Okay. So for folks who want to know, all right, before I sign this document, I need to talk to an attorney. That Marshall Chriswell fellow on the radio sounds pretty good. What do they need to do to contact you?
You can give me a call at 724-465-5826. Come see me in the Atrium Building, downtown Indiana, or go online to westernpalawyer.com.
Very good. Thank you so much.
Thanks, Todd.